Okay, good afternoon, everyone. We're going to go ahead and get started with our last panel of the day. And in a lot of ways, I'm excited about this panel because we're going to hear from creators, so the whole reason that we're actually here today. Our moderator for the panel is David Carstens. He's a partner at Carstens and Cahoon, LLP. He's also an adjunct professor here at the law school. And so without further ado, I will turn it over to him.
Well, thank you very much, Keith. Appreciate it. First of all, thank you all for attending the SMU IP Symposium. This has become such a great tradition here at the school, and we have a great treat for you this afternoon in the sense that we have actual customers, we have actual clients here. These are people who are creators of intellectual property, they're consumers of it, they're enforcers of it, and they provide a perspective that most of us don't hear enough of. And so I'd like to start off by giving you just a brief introduction. I was going to hand it over and let each of them do a little bit more explanation of who they are and what their companies are involved with. On the end, we have Ray Liu. Ray is a founder of a company called DC International and another one called Leatherology. We have.
Okay. Oh, no, go ahead.
Then we have Ellen Harris. Ellen Harris is going to provide some copyright perspective based on the experiences of her company, DynaStudy. Then we also have Russell Farr. Russell Farr is a senior vice president at Caris Life Sciences, and he's going to provide some perspective on patents, particularly in the life sciences field. In terms of the overall structure today, I mean, it's a moderated panel, but we're going to try to kind of talk about some of the challenges that come with obtaining IP rights, whether patents, trademarks, copyrights. We're also going to talk a little bit about enforcement issues that have arisen in their experiences. And then finally, we're going to talk about how those war stories have impacted their perspectives on intellectual property, whether it's chastened them or whether it's made them more encouraged to pursue more. So let's start off and learn a little bit more about our panelists. Russ?
Yeah, I'm Russ Farr, and as he mentioned, I'm with Caris Life Sciences. One thing I love doing is talking about our company. Caris Life Sciences, we're based in Dallas. We're based, our corporate office is here. We were founded and we're owned by an entrepreneur, David Halbert, who has a real passion for healthcare. I previously worked for him in a large public company. We were Advanced PCS, and I worked with David there. And then he acquired another company and brought over a number of executives to that company. And, Caris Life Sciences, our primary lab actually is in Phoenix, but we just are actually acquiring, and we just took 110,000 feet here where we're going to be building another lab. Our business is we provide precision medicine, and precision medicine means that for stage 3, stage 4 cancer patients primarily, we do what's called molecular profiling. So we take a look at a tumor, and we look at the molecular makeup of that tumor, and then we recommend a treatment based on that molecular makeup. When we originally started this in 2006 is when that original patent filing was done in 2006. People thought that was crazy. Why would you be looking at a series of biomarkers, of molecular makeup of a tumor, and recommending a treatment? It doesn't make any sense. The oncology community, others didn't understand it, and it was, over that period of time, there's been adoption. Today, it's becoming a standard of care. Today, many cancer patients are being profiled, their tumors are being profiled, and treatments are being recommended based on that. It's an exciting time in this space. There's drugs that are being approved. Many drugs are being approved based on biomarkers. If you've heard about immunotherapies, Keytruda and others, those treatments are based on biomarkers. If you have a certain biomarker, if you have a certain molecular makeup, then that treatment will work. And it's great to know. So essentially what we're doing is we are making sure that cancer patients get the right treatments that we know will work, and also keep off those that don't work, that we know won't work. So if and you think about that, a treatment that won't work is just as important at keeping them off that as getting them on one that will work, because there's significant side effects and other things. We're also moving, as I mentioned, we focus primarily on tissue, but the next phase of our business is even more exciting. We're focusing on blood. We will start doing profiling in the blood. So tumors obviously are invasive. It's much harder to get, but if you can do this same profile through a blood test, which we know we can do and we'll be launching later this year, and then following on that, potentially diagnostics, so diagnosing cancer through a blood test. So all of those things are things we're working on. It's a really amazing time to be at our company, and we're talking today about IP. IP plays a huge role in what we do, protecting the innovations, the inventions, the things that we're coming up with that our scientists are working on every day. Intellectual property is really important for that. And we love doing what we do because we're helping cancer patients. And one thing we do know, and this is something we focus on every day, is if you can catch a cancer early, the opportunity to either cure or get rid of that cancer goes up significantly. So our goal is earlier diagnosis of cancer, and that's really what we're focusing on, and making sure patients get on those right treatments. So very exciting time for us.
Thank you. Ellen?
I'm Ellen Harris. My company is DynaStudy. DynaStudy is a small educational publishing company. I founded it with a former chemical engineer. We're both chemical engineers back in 2005. And we had an idea to create student course notes that align specifically to Texas's educational standards. So at the time, there was a real gap where you had textbook companies and many, many schools not even letting kids take textbooks home. And then there was kind of an onset of some digital materials, but there are a lot of access issues for those digital materials. And we thought, let's see if we can create really concise, clear student course notes. And even for that kiddo who might, have a teacher they're not connecting with that year, give them something that they can take home. It's in hand, it's fully aligned to what they need to know, and help, maybe they're going to be a journalist one day, but they've got to get past that Algebra 1 test and, get that out into the market. So we didn't have any background in publishing or really intellectual property beyond like patent type thinking from engineering, I suppose. And but most people have some exposure to copyrights, and we knew if we were going to start a publishing company, we'd need some copyrights. And so anyway, we launched DynaStudy to the market. Got copyrights, published titles, market liked it, published more titles, and we expanded. But our student course notes continue to be our primary product. And, the students really seem to appreciate biology on 6 pages. And even though the font's pretty small, it's not as small as what they handle on their phones. So that was our start. And we've gone some different direction. We've done some digital and some different things. But at the end of the day, an in-hand, offline summary of everything they need to know with examples to demonstrate first-order application of key concepts and skills is still our bailiwick. And it's a very small company. We sell a small amount of material to a whole lot of customers. And so it makes us kind of unique in the marketplace. The size of this market, because of the cost of the unit cost of the item, is not that great, so it doesn't really attract the attention of the big publishers. They want the tens of millions of dollars for practice test questions, and we don't do that. We're down at the $1 to $10 million market size in terms of potential, and it's not interesting to the big guys. So we're just here batting away doing this niche product, and are still doing it, although currently on a much smaller scale right now. So we'll have to see where the company goes.
Thank you, Ellen.
Yep.
Ray?
Great.
Hi, everyone. My name is Ray Liu. I run a company called DC International, and we have 2 separate e-commerce properties. One is called Leatherology.com, which sells personalizable leather goods, and the other is called the Cover Store, which is outdoor furniture covers. And what they both have in common is that they are direct-to-consumer only. So we're in retail, in the e-commerce space, pure play e-commerce, and it's all about scalable, made-to-order customization. So kind of as a, founder or business owner, I would have never thought years ago when starting a company, I would need to have a line item for legal costs, especially legal costs around IP and trademark protection, but had a lot of experience and dealt with that over the last few years. So, yeah.
Well, thank you. Well, I'd like to talk a little bit first about obtaining IP rights, and I know each of you kind of looking at it from a different point of view. Russ maybe a little more from the patent side, Ellen from the copyright side, and Ray from the trademark side. But there's certainly some hurdles to obtaining IP rights, and not just the financial hurdles, which are obvious and clear, but other times there are statutory hurdles that you've got to clear as well. And I thought we'd talk a little bit first about Caris Life Sciences, because I don't know how many of y'all are patent lawyers, but there's a lot of case law out there that deals with inventions in the life sciences field, and some prominent Supreme Court decisions that have put real hurdles in place. And so I pulled one of your patents just to provide an example. This one's called Circulating Biomarkers for Metastatic Prostate Cancer. And I started trying to read it, but of course it lost me pretty fast. But when I see the word biomarker, of course, I think of that as a red flag because of some earlier cases that I've heard about. So tell me a little bit about the Section 101 challenges that you run into, just proving that this is patentable subject matter.
Yeah, I think, 101 was really, it was kind of a non-issue for when we were originally filing, going through these patents. But as you mentioned, there was a new test that the Supreme Court came up with for patent eligibility in around 2012 timeframe. So essentially introduced a test which is commonly known today as the Mayo-Alice test, which has exceptions, certain exceptions for patentable subject matter. So, so as we've prosecuted our patents, that's become a primary issue. A primary rejection from the Patent Office are 101 rejections. So, so it's something that we've had to really spend a lot of time on, and it's been used to invalidate many patents over the years. And we're seeing, we're not seeing that stop. I mean, there's been a lot of talk on Capitol Hill about modifying Section 101. We actually testified, our Chief Scientific Officer and President testified on Capitol Hill, and we've worked closely with both the House and Senate Judiciary Committees on developing language that potentially could solve this issue. It's interesting, we were talking earlier today, there's constituencies that really like the state of 101 today, and frankly, it's gotten rid of the patent trolls in a lot of respects, and so there's a large constituency that says, hey, let's leave it like it is because it's great, it keeps these software type patents from being issued or they become invalidated. But on the diagnostic side, it's become much more complicated, much more difficult when there really are actual inventions. And I think what we've seen is the Federal Circuit itself has kind of thrown its hands up. There was an opinion that was issued where almost every single judge on the Federal Circuit was saying, look, Supreme Court, please take a look at this and resolve it. Unfortunately, the case just went up on cert. That Athena versus Mayo case was just denied in the last few weeks or last month or so. So the Supreme Court won't be taking a look at it. But there's still an opportunity at Congress to do some work on that front. But for us, that's in this diagnostic space, it's become a real challenge, and it's something that we have to really focus on. When we're drafting, when we're putting our claims together, when we're drafting those patents, that's top of mind, is how do we overcome this 101 objection that we know we're going to get. So.
Yeah, you mentioned that some of the early cases that you had predated some of these more difficult tests that are in place now. That said, I guess the tests also bring into question the value of some of the assets of the company, the intellectual property assets.
Yeah, I mean, it's interesting, even in this today as we talk to investors, they apply relatively low value to an IP portfolio that we think is robust and strong. And the reason for that is they see kind of how the Supreme Court is looking at it, how the Patent Office is looking at it, and they think, the chances of this really surviving and being enforced are relatively low. So we're, so the ability to raise capital off your IP portfolio, you got to bring something else to the table. They're not going to apply a significant amount of value today. Now, if you go through the enforcement, if you enforce those patents, you get them enforceable, then sure, you're going to have some real value to those. But without that, we see the investment community, at least for now in the diagnostic space, are saying IP is kind of something we're not going to apply a lot of value to.
Okay.
So.
Now, Ellen, in your situation, you're really relying on copyrights to protect your DynaStudy or your Dyna notes.
Right.
Any issues with the Copyright Office in terms of, a compilation of math equations, for instance? Is that something that you found sailed through the Copyright Office, or?
Well, we would never describe our product as a compilation of math equations, for one thing. But I get that, especially if, you look at it, there are a lot of math equations on there, and certainly we're not saying we invented any of those. So it's a good thing for copyright that, the bar of copyrightability is very low. But, if you're going to defend your copyrights, then you need to have, I feel that you would need to have something that the value of it is clear. And if all you've done is compile, a list of equations, for example, then I think you'd have a hard time, getting a jury of 12 people to, apply much value or determine much value for your patents. So, it was actually, maybe at first glance, you look at it and it looks simple, but the process of creating it is extremely intense. It's many, many hours, very tedious. And what we found is that when you take the challenge of getting a lot of information in a teaching and student understandable way into a very, very small package, it really changes your wording, your approach, the arrangement, the thinking, the examples you choose. And so, in fact, obviously if somebody scans my product and I see it online, it's easy to recognize, but also when someone retypes my material, I can recognize it instantly because the wording is so succinct and precise and just different, has a different flavor to it. We don't use sentences and paragraphs. It's very choppy. So, so we actually didn't worry very much about copyrightability ever until we were at trial. And then that was one of the defenses that was raised by the defense, is that we didn't file our copyright applications correctly was a defense that they raised, and also just generally that it's not copyrightable or something like that. So
there are some interesting doctrines in copyright law that kind of are touched on with your sort of a product.
Yeah, there are areas of interest for sure, and so for us, we would have had a difficult time if the folks doing the infringers had copied just portions, right? But in our case, they had copied every page, So in that situation, it's much easier to say, okay, we have a clear copyright. The Copyright Office issued the copyright, and and here's if you wanted to go into case law or whatever, here's the reasons it is copyrightable. But additionally, they copied the whole thing. So then, we were in a pretty strong position, but it still was very frightening, just to have those. I mean, we were hoping that on summary judgment, some of those defenses would be wiped out by the time we got to trial, and the whole process of, there were no summary judgments.
So with regards to your chemical engineering background, which is a fantastic background to have, did you think it prepared you at all for understanding copyright in general? Did you find it to be a tricky field to navigate?
No, I mean, I feel like of the three, copyright is the easiest IP to kind of think about and understand and enforce. So, and actually, all of us have copyright experience of sorts as readers of books growing up. So I think there's a little bit of familiarity, and it was very comforting when we first kicked off, because we actually had the same questions. We didn't know the detail when we started as chemical engineers. We had a IP lawyer that helped us incorporate, but they also did IP, and when he described how low that bar was, it was like, oh, okay, well then no problem, and so it worked out.
Your product made me smile when I was reading up about your product, because I remember in classes myself back in college, once in a while, a professor would let you bring in a set of one-page set of notes, and I never realized I could write so small.
Right, right.
That's what I could do when I was allowed to have that one page.
Exactly.
That's my security blanket for the class.
Yeah. By the time you built your security blanket, you probably didn't need it anymore, right? That's the
Yeah,
key.
now, of course, with my eyesight going so badly, I could never
Right.
read the notes. If I ever found it in in some box somewhere, I'd like to go, what is this?
Right.
Well, Ray, tell me a little bit about trademarks and how y'all develop trademarks and some of the issues that have come up with
Sure.
getting them. By the way, I put the cover mates, which I know is one of y'all's.
Yeah, we can talk about that one first. So one of my companies is called The Cover Store, and we sell a product called CoverMates, which is a line of outdoor furniture covers. And I think when we first started, this is maybe 10 or 12 years ago, we trademarked a version of the logo that looked different and had an umbrella on it, and it said CoverMates, but we didn't get a word mark. So I think at the time we were working with a firm that wasn't like specializing in trademark, and so maybe there was some strategic mistakes that we made. But a couple of years later, we realized we had to actually start all over. And so we refiled, and in the process of doing that, we had to expand the classes. We sell lots of different things, chair covers, umbrellas, grills, cars. But what was happening was we would have these competitors coming to us, giving us cease and desist and saying, hey, actually, I own the trademark for CoverMate for personal watercraft. So it's this like tiny carve out, and they own something very specific, and we weren't monitoring, and the patent office or the trademark office had issued that. And so then there's all these legal questions over how do we proceed and get our marks actually registered. And so there ended up being a carve out. So that is just like one thing that happened. But I think if we had been more strategic from the get-go and really thought about our business, sat down with our merchants and said, okay, what's the 5-year plan? What categories are we going to go into? How can we proactively start to register these so we don't have to deal with this later on? And then in my other company, Leatherology, when we started, we were just selling domestically. And so we didn't really think a lot about international. So we got our mark, and how you market in terms of retail is drastically different now. Social media is this huge thing, and so it doesn't matter if I'm selling in the US, if someone else on Instagram is using the Leatherology handle in a foreign country, it's a problem because I start having customers asking me, am I this company, or trying all these like switched gears. So that's been really eye-opening. We have gone after a few companies in different countries where we had to tell them to sort of knock it off, and in some cases we've been successful, and in some cases we haven't. But that's because we didn't start the international registration of Leatherology until probably 4 or 5 years ago. And I think having Madrid Protocol was helpful in terms of getting a bunch of countries from the get-go, but it's very costly. It's by class. And there's marks in addition, or logos in addition to trademarks, and so it's kind of like you have to do it if you want to eventually scale your business or have value in your brand and be able to, whether you're selling your company down the line or literally just trying to prevent people from, entering your space and creating customer confusion. So.
Well, there certainly are statutory challenges to obtaining trademarks, and sometimes it's just the competitive marketplace.
Mm-hmm.
There's also internal challenges. Harvesting the IP. I would imagine you all have a substantial scientific staff at Caris, for instance. How in the world do you start off sensitizing them to the importance of intellectual property and the importance of disclosure, but only the right kind of disclosure to y'all?
Yeah, I think that's a critical part of protecting your IP is ensuring that your scientific staff understands why, how, what needs to be protected. And, going back a number of years, we used to have what we called the IP committee. So it was a group of the scientific team when it was relatively small, and they would meet and we would talk about what's happening on the IP front. What are you developing? What are you working on? What are you looking at? So we'd have the IP group, the IP lawyers there, and a number of others. We also have invention disclosure forms where they would fill those out and provide a basis for their invention. But kind of fast forward to today where we have a significantly larger scientific staff, and I think it's becoming ingrained in the team. They understand, the primary scientists really have a good understanding of the need to protect IP, and it's something we talk about really constantly. You know, when we're developing these new products, when we're developing these new tests, they need to be protected. And our primary IP lawyer in-house, he's very good about engaging with the scientists and making sure they understand, and they work really closely together. So it's exciting for them. It's exciting for them to have an invention patented, to be on a patent that's filed. And so I think over time we've developed a good understanding from the scientific team. They're very attuned in to what needs to be protected, and we are constantly preaching. Anytime they're going out to give a talk, we need to see that because you may be disclosing something that we need to file on. So there's many times where we get a copy of their talk or a paper, and we go file on that day to make sure it's covered before they go out and disclose. So, you know, it's really constant vigilance is what we've determined that we have to do, and we have to make sure that they're really tuned into what we need to protect. The other piece of it that we do is we really continue to focus on trade secrets. So there are many things that you may not patent, but we want to protect. And so, you know, we make sure we compartmentalize that everything isn't broadly disclosed to everybody in the company, that, you know, if you're working on something very specific, let's keep it to that group that's working on it and that group only. And then we try to make sure that we've built in protections around trade secrets. The other thing is we make sure that everyone who's working on anything that potentially could be patentable has signed an invention assignment document. So those inventions are assigned to us, and we've had inventors, people that had invented things that left on bad terms, you know, and so we've had to go back and fall back on those invention assignment documents when we're filing our patents and when we're prosecuting those patents through the patent office. We've had to rely on those, and we've been able to do that. But that's an important part of overall protection, because the last thing you want is somebody's left the company, invented something, and you don't have anything tying them or locking that IP down. So.
Just out of curiosity, when you have a scientist announce that he's going to leave and perhaps even leave to go to a competitor, how do you all handle, again, sensitizing him to his obligations to
Yeah, we're
stuff with him?
two things. One, we try to not let him go to the competitor, so we have protections in place to avoid that. And we've actually had, you know, scientists that wanted to go to a competitor, and we've had discussions with that competitor saying, look, that won't happen for, you know, a variety of reasons, but also ensuring that they understand. So when they're exiting, we walk through with them, here's your obligations. Here's your obligations to the company, here's your obligations for confidentiality, and, you know, we ensure that they do that, and then we'll follow that up with a letter. And sometimes we'll send a letter to their new employer saying, just so you're aware, the employee that you've hired has the following obligations, and our expectation is that they will abide by those obligations. So.
Very good, very good. Ellen, tell me a little bit more about, with DynaStudies, you're coming up with these notes.
Mm-hmm.
Is it always done by employees, or do you have outside contractors who help assist you with the graphics and the
Right.
layout and perhaps sometimes even the text?
Yes, I mean, we have used vendors and contractors to help, you know, create the notes. Our employees have always done the lion's share of the work, but even with our vendors, we did work for hire contracts and made sure that was protected with our, we use teacher reviewers as well as other editors and such. Mostly at the tail end of our process is when we bring in additional contractors, and we always did independent contractor agreements with work for hire clauses in there. And yeah, some of that stuff, I had a very conservative business partner, which was lovely. I mean, she was a worrier, and so I'm more of a risk taker, let's do it. And she was very good at balancing me out and saying, you know, let's dot I's and cross T's. And I was very thankful for that when things got to be more exciting.
It's interesting that you had actual teachers from classrooms, I guess,
Mm-hmm.
take your material and would they actually test it with students then to kind of see how it worked with the students?
Well,
or did they just kind of review it for completeness?
yeah, mostly reviews for completeness, applicability. Would a student understand this? What else is needed? Where could we shave off? That kind of thing usually. But we did do some in-class studies as well, like, what's the word? I'm not thinking of the word, but, well, practice runs through new products. You know, if we were trial runs, did some trials. And that was typically when we were coming up with something brand new. And but usually it was more the editor type role. So.
Now, Ray, you'd mentioned a little bit about international protection. This is something I'm going to ask Russ as well. But, you know, so far we've talked a lot about domestic intellectual property. How do you make the decision about when to go ahead and tackle doing trademarks outside the country? For instance, you'd mentioned the Madrid Protocol.
Yep.
At what point does that become the benefit is worth the cost? How do you make that business decision?
With difficulty. I would say, so interestingly, we have gone the international route for Leatherology's trademarks. We have not done that on cover meats. And so one of the things we looked at is, where do we see our business going, right? So in all my companies, I care a lot about building brand. I'm going to start shipping internationally, so I have to lay the foundation for that. But what really was the impetus was a couple of years ago, there was a company in Indonesia using Leatherology, copying our logo, some of our designs on Instagram, very aggressive. And I couldn't stop them because I didn't own the mark there. So what I did do was register it everywhere else to help minimize something like that from happening again. But I very much want to expand internationally. So that was part of the strategy because social media is a component of our business and international is local now. So, you know, somebody can post from anywhere in the world. There's market potential anywhere. Whereas I sell covers, which are much more specific to the U.S. You've got to have a yard in the first place and furniture to cover. And it's not to say that the mark isn't valuable, but it's more of a commodity than it is brand. So we kind of looked at it from a cost analysis standpoint and made some decisions that way.
Very good. Very good. Well, in each case, your companies have done a good job of harvesting your IP, checking your IP, making decisions about where to protect it outside the United States. But what happens at that moment when you start to see something on Instagram that looks like an infringement, or you see a competitor pop up in the life sciences business that starts making claims very similar to which your company should have exclusive rights to, or you start having rogue copies of DynaNotes? You know, at some point you have to make a decision about it's time to enforce these rights. I'd like to talk to each of you a little bit about what the trigger points were that led you to make the decision to go ahead and enforce your rights. Russ, I know you're actively
you bet. Here we are actually, and you know, we really own what we believe are foundational patents in our space. So there are a number of competitors in the molecular profiling space, and one of them in particular, we believe, essentially, you know, copied what we were doing, took our IP, and launched a very highly successful company. So for us, as we got a series of patents issued, the discussion was with our CEO, with me and other of the executive team is, hey, we got all these patents. We have a competitor that essentially launched a company off of our IP. You know, what do we do? If we're not going to enforce them, what value do they have? You know, and so that's a pretty good question. You know, if you're going to do all the work to get these patents, and then you don't enforce them, what value do they really have? And so we determined that, you know, it's time for us to move and to enforce our IP against a competitor. Now, certainly there was all this stuff happening with 101 and other things at the time, and so we had to really think through how we wanted to, you know, what we wanted to do. And so we took a look at the space. We knew there were many, many competitors out there that were utilizing our IP. And so we decided, you know, let's go after the biggest target, the one that was the most successful, the biggest target. And we decided that we would pursue litigation. We'd file a claim against this competitor. Now, the process to get from that decision to filing the case was significant. We worked with an outside law firm. We wanted to really diligence our portfolio from an outside perspective, really understand what are the weak parts, what are the risks, you know, what's the value? Because if you're going to invest in an IP case, it's going to be many, many millions of dollars. if you're going to enforce this and take it all the way through. And so before we wanted to make that significant investment, we really wanted to diligence the portfolio. And we did that. We took, I'd say, 6+ months working with an outside firm to really get a full, deep understanding of this patent portfolio. And then we made the decision, yeah, this is going to, let's go forward. Now, the litigation, the enforcement, I don't know if you want me to talk about that, but.
Well, not in too much detail because
Yeah.
it's ongoing, but, obviously with patent litigation, you've got some additional challenges with what are called inter parte reviews, or IPRs.
Yeah, so we filed the case, and, the first thing the competitor did, as you can imagine, they filed a motion to dismiss under 101. First thing that happened out of the gate. So then we're briefing that, we're litigating that. 1 year into the patent case, literally the 1 year, the day we hit 1 year, they filed for an IPR. So you essentially pull the case out of the district court and you take it to the patent office. So we've been litigating that for the last year plus in the patent before the PTAB. And, we're right in that process right now. We had actually an oral argument on the first set of patents about 2 weeks ago. We have the next oral argument on the second set of patents next Friday. So we're right in that space. But, it just shows you that patent litigation does take a long time. We're a year into it, really just litigating a motion to dismiss under 101. Now we got pulled out to the IPR. I suspect whoever.
We're not even into the infringement.
We're not even into infringement. I suspect whoever wins or loses are going to appeal that to the federal circuit. So this case, these cases take a long time, and you have to be up for that. You have to be up to really engage in litigation for a lengthy period of time.
I'm impressed by the amount of time and money you spent on the due diligence prior to filing the suit. Having an outside firm search, look for additional reasons for invalidity, trying to go in with your eyes wide open as to what the defense might circle around.
Yeah, and we wanted to, because we really wanted to understand that. We wanted to say, look, what is it going to look like? We wanted them to take the approach like they were on the other side of the case. Poke every hole in it, make every argument, look for other references, and really go through that case. And I think it's been hugely valuable for us. We haven't been surprised at all. In fact, the only thing we've been surprised about is some of the, some of the arguments that have been made. But we haven't really been surprised because we kind of understood everything. And so
a good investment.
it was a great investment, and it was a great investment for the executive team too, for our CEO, to really, get an understanding for what this is going to look like, what are the weaknesses, what are the strengths, and how's it going to look going through. And then you make that investment. Like I said, it's many millions of dollars.
That's a great point, because, the lawyers may have a lot of knowledge in their head about what the risks are and so forth, but ultimately, they've got to be able to communicate that with the executive team and ensure that they understand what the risks are so they can make their rational business decision.
Yeah.
It sounds like this was a great opportunity for
Yeah,
the
but
executive team to be taught.
Yeah, absolutely, and really understand kind of what the case is going to look like. So.
Now, Ray, you were talking about an infringer in Indonesia, but also you talked quite a bit about social media. And you're right, international is local now. One of my kids is hooked on this thing called TikTok, which looks, I don't know, I'm not sure what to think of it yet. But, there's so many new social media channels. It's not just looking at Instagram anymore, is it? It's monitoring the world through 50 different potential channels.
Mm-hmm.
How in the world do you do that? How can you find the infringers when you have a popular name and a popular product?
I think it's really difficult. So, there are a lot of social media options out there. They're not all equally popular, right? So I'm not so worried about TikTok right now. Maybe I should be. But I think a lot of the things we've discovered, they've come to us. It's genuine cases of customer confusion. We have somebody calling our customer service line like, hey, I saw this on, X account, or the foreign country's version of Leatherology, an influencer tags the wrong one. They tag us, and then suddenly all their followers are contacting us saying, how do I buy this product? Or, is the one on how do you ship your product to Mexico? So I think,
Ray, you were telling me earlier,
Yeah.
I thought this was fascinating, like a Mexican actress
yeah,
who was a paid influencer,
yeah.
but then
She tagged the wrong Leatherology. So that's how we found out about that one, because we had a lot of people writing us in Spanish asking how to ship their products to Mexico. So yeah, they changed their name.
So for instance, the infringer in Mexico, though,
Yeah.
if you only have a social media lead, do you ever find it difficult even just to find the infringer?
Yeah, I mean, so I think if they have a website, it helps because you can do the who is search and try to like track down who owns the domain. And I think that's how we found this particular person in Mexico. But a lot of companies, they start on social now because the barrier to entry is so much lower. To go the true direct-to-consumer route, set up a website on, Shopify, Magento, whatever it is, and like build that whole thing out, that's actually quite difficult. So usually when we find infringers, they're much smaller players, and it's like they're on Etsy, they're on Instagram, they're on Facebook, they're doing like private chats and trying to sell people products. So I think it can be challenging, but we also look at, is it worth our time? Photo infringement is rampant. If I go on Alibaba, I like have a heart attack sometimes because I'm like, that's my photo, that's my photo, that's my photo. But it's not necessarily worth your time trying to pursue. And I was telling David earlier, yesterday I had my customer service manager emailed me, somebody on Etsy is using our name. And I think it's unintentional, it's a very small shop, so I just sent them a message and I said, hey, I'm the trademark owner, you need to stop because lawyers are expensive. So if you can handle, you kind of do some assessments, if you can handle it on your own, you kind of assess the situation. Sometimes it's easy to tell people to knock off, and sometimes it's not. And that's when you have to get, actually get your lawyers involved, so.
Thank you. Now, in both of y'all situations, it's infringement by a competitor, or even if they may not be aware of you, they're clearly a competitor. Now, Ellen, you had a situation where one of your customers
Yes.
became the infringer,
Yeah,
which I would think would make the calculus of deciding to sue much more difficult.
Yes, yeah, that's very accurate. I didn't really get hard data until 2012, but there was some suspicious sales data and things that, kind of had my eyes open to these possibilities. But
And go ahead and tell them, the infringer was the Houston Independent School District.
yeah, our largest customer is Houston ISD, and that's, we had multiple infringers, to be clear. I mean, tens of districts. And the only, hard data that I can find is what's in the public domain. So it's only if a teacher, for example, bothers to put a file up on the web so that his or her students can download it, and then I'm looking for infringing files and I find that file. But we had or DynaStudy, which really at this point is me. So I had kind of an evolution from 2012 to 2016 where you're constantly recalculating. And the first 2 to 3 years, if someone said, man, you should get a lawyer, I'd go, ugh, just no way. I mean, these are my customers. And if I sue one, that could have, major business impact. And in fact, it did. I mean, it was worse than I would have even imagined. But that evolution kind of shifted. It began with really a vendor-like, please take it down, please research what happened and try to go back to the sources and make sure that they take it down, and please let me know what you learn so that I can continue to try to scrub the internet or, deal with this issue. And I will say that for the most part, districts were very responsive, and they said, oh my goodness, was so sorry, and they would investigate and they would report back, and I would, feel good about that, even if sometimes the information that was reported back was pretty disturbing. I mean, we had one of these files that ended up in a Dropbox for a person who was doing training across the state of all 8th grade science teachers, and that particular file it went everywhere. And, 8th grade science was just one of our products, but it was probably 30% of my sales, 25% of my sales. So yeah, I have 187 copyrights, but the money's made on, a small selection of them. And in fact, science was our number 1 selling category of products. And it was definitely, 92% of infringement I found online was science. And then those science sales went, over that course of time, starting in 2012. So.
And you mentioned that your sheets include, of course, copyright notice.
Oh, yeah. Mm-hmm.
Clear little C in a circle, followed by
Right.
and the date of first publication.
Yeah.
but you were finding that they had actually covered that up before they had scanned it.
Yeah, many times it was covered up or all the margins were clipped off. So, and it was interesting because, that's why the DMCA law was written the way that it was for instances like that. And it was true that while there were many, many, many copies and scans, eventually, I think about 150 different unique file names that we have in our possession now of, copies of our products, that it was only the ones that had the margins cut off and the do not copy notice terms and things like that covered up that went viral across the state. Because it really gives a recipient of this thing, even if they know darn well who DynaNotes are, because they're a current customer, they can say, I had no idea. And, that makes it hard to, you can still enforce, but what are you going to get? Yeah, you're not going to do that well in that situation. And so, that it was really impactful when that information was taken off. And I don't think, again, because of confusion as much as I got my excuse for why I'm allowed to use
I guess
this.
the thing I'm trying to drill down to is,
Yeah.
how bad does it have to get before you sue one of your big customers?
Well, and everybody, of course, that's their individual thing, and you don't know, like, how bad will the market reaction be if you sue. But I can say that we started with the vendor-like, please take care of it approach, and we stayed on that approach for quite some time. We attempted to launch digital solutions instead of selling the print materials. So that was kind of a business strategy approach. Well, let's shift our model, let's do mobile apps, and then we can kind of lock down and control this a little better, and the whole school will have access anyway. And, anyway, the customer base didn't want our stuff digitally. They have enough stuff digitally. They wanted the in-hand, offline, something the kids can look at. So that didn't go anywhere. Our third approach was to, continue the vendor-like thing, but effectively to accept the loss, to say science is, it's probably not coming back, and it wasn't until actually there was a couple pivotal moments, but it began to spread into social studies, which was my new #1 product. That was an eye-opener, and we had an instance where our sales rep had dropped off some materials at a school and had come back to pick up those materials after they'd been reviewed, and there was a piece of paper taped over the terms of use, and she said, this has been copied. And the person said, well, not by me, and took the thing off and handed it back. And it was a language arts product, so it was a new product, and of course we had geographic spread, we had increased numbers, and then it was turning into my other products. And that was the point where I got a little irritated, and And so combined with that was, of course, the process of finding somebody to represent DynaStudy. And I felt I found the right lawyer, and he was willing to work with DynaStudy on a hybrid model, so I wasn't paying $4.75 an hour at the beginning, which would have been untenable, but instead, an hourly rate with a kicker at the end if we were successful, which was a lifesaver. And
It's the best thing.
yes. Yeah, we had a happy ending, so that was good. It was a miserable process. It was a happy ending. So.
You've been through the entire trial, though, too. And
Yeah.
if you had to point to one thing in the trial where you wish you'd have gotten a little more advice in advance or a little more warning, hey, this might happen. Was there any part of the trial where you just thought, oh my gosh,
Or the whole process, yeah. Some of the things that come to mind are, the importance of the learning experiences anyway, was the importance of the soft stuff. I felt like we had a great team to look like a team and to be respectful of each other and professional, and it all reflects on your authenticity. You're expecting 12 people you've never met before, and you don't even get to have any side conversations with them about anything, And you want them to, of course, believe what you're saying and believe you're who you're acting like you are at the moment. And if I'm on the stand on my direct and I'm answering questions and I seem forthcoming with information, and then and I'm smiling and I'm saying, yes, sir, and then I go down into the pit and I'm talking to my lawyers and I'm rude to, somebody, right? Or then the cross comes and I completely change demeanor. Not that a direct and a cross are a similar experience, but you want to look like the same person going through those experiences. And I got some really good advice from my law team and our audiovisual guy, He gave great advice. He'd been in tons of court cases. So there's kind of the hard part of it and the soft part of it on the way that I think about it, the factual side and preparations. But discovery was the area that I expected it to be kind of long and lengthy, but I thought it would be fair. And there were things during the leading up to trial that just were so obviously unfair in my view. And of course, I'm not a lawyer, so I don't have the other instances to compare it to. But I just felt like, wow, if you know the names of titles that need to be searched for, how do they not get to search for them? And, we had an instance where, we were seeking metadata on the files, and it just seems like, of course, you're supposed to get the metadata, but it was just a fight, and it was going on for months and months and months. And we had gotten some metadata with, rows of it that were missing. And we were like, well, where are these rows? And they said, we don't have it. And then when it was reproduced, there it was. Very interesting information was in those rows. And in fact, the first file that was one of the first that I remember exhibits that was put in front of me, and I was asked, you don't know who did this, do you? And I said, yes, I do, because that was the missing metadata that had magically reappeared, but I don't think they realized it was now known to us. So that was a lovely moment, honestly, from my perspective. I felt like, there is some karma in the world that if you, but I really worry about the whole system, the whole discovery process. I feel like if turning over bad facts hurts you and not turning them over doesn't hurt you, why in the world does anybody turn over bad facts? And I just feel like, has that shifted incredibly so, or am I just becoming aware of how nobody turns over bad facts or something? Or should I just feel so incredibly thankful that we got what we did get in discovery, which wasn't zero by any means. So, that's the whole thing where I just feel very unclear of how it should go and how different our experience was, or is that just how it goes? But.
Well, all of you have had some experiences now with the struggles of obtaining stuff, the struggles of identifying infringers, the struggles of enforcing. We've only got a few more minutes left, and I'd like to kind of have each of you just provide kind of one final insight. How has this affected you? How has it changed your perspective? And then I'd like to open it up for questions and answers if anyone has some questions from the audience. So, Ray, why don't we start with you?
I would say if you're starting a business or you want your business to have longevity, trademark and patent, IP basically has to have a place. And it's not something, again, that I realized at the beginning, but even if you're not actively pursuing people, other people will come after you if you're not properly protected. So it's a cost of doing business, and learn that the hard way.
Ellen?
I probably already talked too much, David, but it's definitely intellectual property, the ability to enforce it, not getting it, but that enforcement step definitely has shifted, my ideas about what kind of business model is, realistic, what can really function in this day and age. And, things like scanners showing up in schools was not on my radar screen in terms of having a massive, massive impact on my business. And that little fact and that little change in the market, I think, was a little fact that changed everything. I just
threw this online because you streamlined science text students' course notes.
Oh, yeah.
And you mentioned a change in business model, that you're
Yeah.
being charged by seat, not
This
by
is another attempt, yeah. So we launched this in fall 2018, and so literally, it used to be you get a printed product for about $7, and now for $1.99 a student enrolled in the usual grade, you get a PDF. It has your schools identified on it. You have print permissions. They last until the TEKS change, so it's not an annual fee. And we give written permissions. The other side doesn't need to sign. We're just, here's your written permissions. And so we're trying to make it really simple, really, school-friendly, business-friendly, but we still need to see if the market will forgive us. So, my sales at this point are less than $100,000 a year, so the market did very much punish us. From the time that we filed suit, every year sales dropped by about a third, and it lasted 3 years, so, So, it's you keep trying, and then I'm in data collection mode. Like, is this going to work? Do we need to do something different? And I'm hoping that we can come up with a model that still makes sense.
Russ, how about yourself?
Yeah, I think for us, what we've learned and what we are learning is that we need to have an overall strategy for IP protection. So it needs to be kind of multi-pronged. So, looking at it certainly from the patent protection, from education to the scientists, and then to other types of protections that we're going to implement. So we really have to have kind of an ongoing, constant process. And just by way of example, some of the new products we're launching are combining not only the biology, the biotech, but also AI and machine learning. So we're now combining both sides of it. So we have to really have an overall strategy, kind of a multi-pronged strategy, from protecting IP, with patents, trade secrets, and that's really what we continue to do. We just have to be constantly vigilant about making sure we're protecting our IP. And also in other relationships that we have. We're constantly involved in, for example, negotiations with pharmaceutical companies where we're working on products with them. And, there's always an IP component to that, making sure we're protecting what we own, not giving anything up. So it's just a constant, for us, IP is a core part of our business, and it's something we really have to work hard to protect. So.
Thank all three of you. I would like to open it up for some questions. Yes?
This is a question not only for the panelists to ponder, but everybody in this room. The question is, how can we do a better job of starting to educate our K-12 students about intellectual property and copyright in particular? These days, most kids know nothing about copyright until they take a freshman orientation week, which may teach them something about copyright, particularly plagiarism, and they tell them that their faculty members may be using the term in plagiarism detection system. Anyway, in the last few years of my 25-year service in the Copyright Clearance Center, I tried to get them to pay some attention to this and develop some resources for K-12. They never got around to it. I approached the Frisco school system, which has a wonderful program of independent study where students are encouraged to shadow professionals in various fields. Some of those professionals are, of course, creators of copyrighted material. Students themselves may be creating copyrighted material all along. When they write a poem on the napkin in the lunchroom, they're creating copyrighted material. And I think it's far too late to start educating them only in college, and many students never go to college. Students are usually starting to get really immersed in social media, which has all sorts of copyright implications, as early as middle school and even earlier than that. So my question is, what can we do to really change this around and get students learning about these things? Because all the problems you're talking about might have some better outcome if people understood what this is all about before they get to the stage of violating copyrights and knowing what's right and wrong. So, big question.
I mean, I can start an answer, which is, obviously there's classes in 10th grade that are still required curriculum around social studies, and that curriculum is established by the state.
Mhm.
I suppose the answer would be to try to put it into a mandatory class that all kids got. Seems like kindergarten through 9th grade is probably a little too young. They're probably too young to really get it. But maybe you could have a unit put in at that point in 10th grade.
If it's not tested, it doesn't sell, but maybe I could, I could create something and give it away.
Yeah. But no, I agree with you that,
Yeah.
it'd be great if kids had a better understanding of it.
Mhm.
I couldn't agree more, and I think that actually, and I don't think that K through 9 is too early, because if you think about the material that's consumed by the children, to our last panel, it's a lot of it is not just copyright infringement, but all sorts of kinds of infringement. It's the norm, it's normalized.
Mhm.
And I think that so I'm impressed you can sell any of these,
Mhm.
because as a professor, you are in a position where you start questioning whether you should develop materials, right? Because it's your intellectual property, which you hold, gets distributed absolutely everywhere, and there's not much that we can do
Mhm.
to go after, Coursera or whatever site there is that's selling the material. So that, to speak to your question about what does that do to innovation, well, I think the implication is pretty straightforward. There's more and more canned material produced by the publishers, and less, intellectually different material that's provided in written form to students.
Yeah. Copyright's a tough question because,
Yeah.
Sometimes you're right, that you don't want them to just grow up to be copiers. You want them to certainly create new material on their own. And yet, copyright's not absolute either. How do you start teaching them about the fair use defense and transformative works and so forth? It gets pretty deep pretty quickly. But certainly you could teach them, kind of the 2 or 3 basic ideas and hope that that's enough to tide them over.
Yes, so it's just a comment because my son is a student here at Highland Park Elementary School. They teach them copyright.
Do they?
Yes.
Interesting.
And they start in 2nd grade and they do 2nd, 3rd, and 4th grade.
Well, what I meant to say was K through 2 is really too young. A lot of smart 2nd graders out there.
But they do just, they start with the very basics. They do not copy, what it means, and this also sort of thing.
Yeah.
So you can do that.
And certainly you got to start teaching intellectual integrity early.
Yeah, exactly.
Right, I think if you're doing engineering and math, et cetera, early on, those are the kind of places you want to be in. Is to learn when they're creating something, what they can protect it by intellectual property, but also what they can't do. During picking a jury for Ms. Harris here, we asked, hey, you find it online, do you know whether you can copy it or not? And the answer was, it's online, I can copy it. That was a younger juror member, but it's not her fault. The issue is not learning enough early on to where they say, if I see a picture, a poem, a recording, whatever it may be, that happens. And so I look at it as, if you want to teach engineering and being creative and innovation, have that segment, yes, protect your invention, but also know what you can't do. And I get we have defenses, among defenses in every different IP section, but at least what we should do is have the idea of know what you can't do out there as well.
Very good.
So I'll just put in a plug. I mean, the question related mainly to copyright, but I'll put in a plug. So I practiced for 7 years before I became a law professor at Baker Botts, a large firm in town. And I would encourage any firm to do this with all the various school districts. They would do it. A lot of school districts have an invention convention or whatever they call it, a competition. Students come up with ideas, often involving duct tape. But anyways, very basic to more complex. And then the law firm would go in and judge the most patentable invention and actually draft and file a patent application for the students, just to educate them. Another plug would be the Dallas Bar Association IT section. There's a young lawyers committee that actually sends out attorneys to the local school districts, high schools, to provide education at like career days or for particular classes. So there are resources, and I'm focusing on patent office that haven't been mentioned, but there are resources in the community.
The Girl Scouts can get an IP patch, by the way, if you haven't heard. That's another thing. Talk to a Girl Scout troop.
It's so different. When I got out of law school, IP was still kind of the redheaded stepchild, and now, of course, it seems so front and center in everything. And maybe that's just the changing nature of our economy. But yeah, even an IP patch for Girl Scouts, that's amazing. All right, any further questions? All right, well, if not, let's have a round of applause for our
Thank you very much. That was great. So before we adjourn, I have a couple of quick announcements. So one, in your materials, there should be a light blue evaluation form. We'd love if you could fill that out so that we could get feedback and make our symposium next year even better. I want to, of course, thank my co-director for his hard work in helping with this, the Ty Center Scholars, and last but not least, of course, Natalie Greco, our Director of Programs and Operations. We have a networking reception prepared outside in the lobby area here. If you can stick around, we'd love for you to hang out, have a drink, a light snack before you head home. And thank you again for attending, and have a good weekend.
Thank you.
Yeah, thank you.